Hi, I'm Keean, and this is a picture of me from when I was 12 years old. Even though I'm pretty sure we didn't need to include this, here is my sources list, in case if anyone wants to find out more about what I'm going to talk about. I'm going to be talking about copyright law, specifically the copyright law surrounding the protectionism of patented medical services, procedures, and products that are introduced to the market. There's also going to be a pretty heavy emphasis on this guy, Martin Shkreli, who is my scapegoat for all of the things that are wrong with the medical industry in terms of patent law. Just as a little bit of background on what patent law is in Canada, if you release a new medicine in Canada, then that item is protected from duplication or replication by other countries or companies for 20 years as long as they are signatory to Canada's copyright laws. There are some exceptions, like the orphan law, by which if a company produces a drug or a treatment that's effective to less than 200,000 people in the United States, which is an odd metric to use because we're not in the United States, then they will receive grants and financial benefits from the government to encourage companies to develop drugs that affect less people. The majority of the time, this system works properly, and it just allows a company like Rogaine to monopolize a non-essential good for 20 years to reap the full extent of the profits allowable to them. This system becomes a problem when it's an essential good that can't be replicated by competitors, and then companies are allowed to set the price expectations to consumers. For example, if dexamethasone, which is a chemotherapy drug, was costing an exorbitant amount, people don't have any choice but to pay it, and it becomes an inelastic good at an extremely overpriced selling point. That's where this guy, Martin Shkreli, pays into all of this. He was the owner of a company which purchased patents from other companies and jacked up the prices in order to capitalize on the potential for unlimited profits from people who don't have any other choice. For example, patients who suffer from cystinuria have a disorder where amino acids will build up in their urinary tract and their kidneys, and there are treatments available and have been for a while to rectify that issue. The treatment is called teopronin, and it's sold under the brand name Thiola, and that medication sells, well, it's sold for an average of $1.50 per pill. Martin Shkreli then acquired the company that held the patent to this drug, and he changed the pricing scheme so that each pill was about $30. That in and of itself is a massive increase, but a consideration that also needs to be made is that this isn't a once-a-day pill. Patients with this disease need to take this medication up to 15 times per day. Shkreli's strategy was to find orphan medications where they had very few purchasers, acquire the patents or the company holding the patents, and then jack up the prices. He later used that for a number of other treatments, including drugs for hypertension, drugs for depression, oxytocin, anti-malaria, and anti-parasitic drugs. Shkreli's success was precedent-setting for the pharmaceutical industry. Later, a company called Mylan acquired the patents to the auto-injector for epinephrine, which is also known as an EpiPen, a drug that is used in emergency situations where a patient is having an allergic reaction and can go into anaphylactic shock without the treatment. When Mylan acquired the patent, the price of one Mylan injector was $57, whereas today it's costing around $500 each for the injectors. While we absolutely felt the effects of this level of monopoly in the industry when we were all trying to get COVID vaccine distributed around Alberta, Canada, and the world, there's a lot of people that in third world countries still do not have access to it because the price points for the drugs are still being set by the companies that hold the patents. This means that distribution in developing countries can be limited to developing countries with wealthy governments, which are infrequent, and wealthy citizens within developing countries. A couple of ways that international governments could cooperate to mitigate some of the dangers posed by medical patents include making exceptions if the good produced by a medicine or a procedure exceeds the potential for monetization by the company, or to allow other competitors into the market, assuming they don't undercut the owner of the patent on price. That's my soapbox, and hopefully I'm there to answer questions, but either way, thank you for listening.